Yes, supplementary list be prepared.
Your Lordship, I leave to mention one matter, Your Lordship. One correction of order, Your Lordship. Order passed on 16th of this month.
Anyway, I've directed.
Yes, Lordship.
Yes, this matter, you 203. Yes, some rectification is made. Mediator has not submitted the report, but it is written that no mediator report is submitted. Anyway, yes, recorded order. Anyway, that will be taken into consideration. Learned advocate for the parties are present. This matter is put up for necessary rectification of order dated 15/12/2025. Stop. In the order dated 15/12/2025, it is observed that no report is received with regard to the mediation proceedings, although the mediator has submitted the report. Let the let it be corrected as and stated that the mediation proceeding report is filed. Yes. Anyway, whatever it is, mediation report is filed. It's on the record. Huh? Other contents remain unaltered.
Into and for the petitioner also.
The opposite party has entered appearance.
So I have served with, on the last occasion, they appeared.
No, no. The opposite party is not has not appeared, then let it be taken up in the next circuit.
Lordship, the next date is fixed on 2nd January. There,
Or
for the evidence before the trial court. And a short stay may be given.
yes, record and order. Learned advocate for the appellate petitioner is present. None appears for the opposite party. Let the affidavit of service file be kept with the record. Let this matter appear before the next available circuit. As the matter is sub judice before this court, parties may seek adjournment before the learned trial court, which may be considered. Yes, call the next. So let it be sent to mediation. No, no, what is the order? Impugned order. Yes. The interim order is going to expire on 31st January. So it will, no, if it is. Yes. Record an order. Learned advocates for the parties are present. It is submitted by the learned advocates that talks of settlements are going on. In the facts and circumstances, let this matter appear in the second week of February before the next available circuit. Interim order stands extended for a period of 10 weeks, 10 weeks or till further orders, whichever is earlier. হয়ে গেছে network। আড়াইটার সময় দিয়ে দেবেন। Yes, record an order. Learned advocate for the appellant is present. As the appellant insurance company has deposited the statutory amount of rupees 25,000, there shall be a stay, ad interim order of stay of the judgment and award dated 12th April 2024, passed by learned additional district judge, First Track Court, Siliguri, in MSC case number 114 of 2012 for a period of 5 weeks from date. Stop. The appellant insurance company shall deposit the entire awarded sum within 5 weeks along with interest as directed by the learned trial court. Stop. In the event the entire awarded sum is deposited, the ad interim order of stay shall continue till disposal of this application. Liberty to mention. Yes, affidavit of service file be kept with the record. And for the appellant. Yes, record an order. Learned advocate for the appellant is present. Okay, have you served this application?
Yes,
Section 5?
yes.
Have you filed your affidavit of service?
Yes.
Okay, learned advocate for the appellant is present. None appears for the respondents in spite of service. Let the affidavit of service file be kept with the record. The application for condonation of delay is taken up for consideration. Heard learned advocates peruse the petition file. Upon perusing the petition and upon hearing the learned advocate, this court is of the view that sufficient ground is shown for condonation of delay. Thus, delay in filing this application is condoned and the appeal are admitted. Stop. Can 1 of 2025 stands disposed. Stop. Can the application for stay is taken up for consideration. As the appellant insurance company has deposited the statutory amount of rupees 25,000, there shall be an ad interim stay of judgment and award dated 7th day of October 2024, passed by learned additional district judge, First Court, Jalpaiguri, in MSC case number 230 of 2021 for a period of 5 weeks from date. Stop. The appellant insurance company is directed to deposit the entire awarded sum along with interest within the period of 5 weeks. Stop. Within the period of 5 weeks, excluding the statutory amount. In the event the entire awarded sum is deposited within the period of 5 weeks, the ad interim order of stay shall continue till disposal of this application. Liberty to mention.
Yes, Lordship, I on behalf of the applicant, Lordship. My lord is directed to serve the Mr. Hugoma to paperwork, Lordship. I have served, Lordship.
Yes, you are appearing.
Lordship, in this case, Lordship, I only pay for interest, Lordship.
What was the award? Let me see.
Page number 70, Lordship.
Yes,
Page number 70, improving order, Lordship.
yeah,
In my paperwork, Lordship.
17.
No, Lordship, 70.
Only interest is not award.
Yes, Lordship.
Yes, what do you say?
And Lordship, in this regard,
So
Lordship,
let
I
it
have
be-
relied upon one judgment, Lordship. There is 7% interest given to the claimant, Lordship.
Yes. Unless it is an exceptional case, interest is awarded. And for if interest is refused, special reasons are assigned. Yes, record an order. Learned advocate for the appellant and learned advocate for respondent number 1 insurance company are present. Heard learned advocates for the parties. The appellant before this court was a claimant in a claim under section 166 of the Motor Vehicles Act 1988 and is aggrieved by the judgment and award passed by the learned trial judge in not awarding interest from the date of filing of the claim case till date of realization. Stop. The learned order, judgment and award passed by learned additional district judge, first court, passed by
First track, first court, Jalpaiguri.
learned additional district judge, first track, first court, Jalpaiguri in MSC, additional district judge, first track, first court, Jalpaiguri in MSC case number 26 of 2019. Judgment and award dated 20th February, 20 February 2025, passed by learned additional district judge, first track, first court, Jalpaiguri in MSC case number 26 of 2019. Stop. The learned trial judge, upon disposing the claim case, was pleased to observe and direct as follows. Set out the order portion. Fold করে দিন। Set out folded. Stop. Learned advocate for the appellant submits that the learned trial court heard, while not granting interest from the date of filing till date of realization. Learned advocate for the appellant relies upon the decision of the Honorable Supreme Court in the case of Janabai and others versus ICICI Lombard Insurance Company Limited, reported in 2022 within bracket 3, TSC 705 within bracket SC. Upon hearing the learned advocates and upon considering the facts of the case, this court is of the view that Section 174 of the Motor Vehicles Act 1988 empowers the court award interest. 171 of the Motor Vehicles Act 1988 empowers the court to award interest where any claim is allowed. Stop. Where any claim is allowed. As per Section 171 of the Motor Vehicles Act 1988, where any claim tribunal allows a claim for compensation made under this act, such tribunal may direct that in addition to the amount of compensation, simple interest shall also be paid at such rate and from such date, not earlier than the date of making the claim, as it may specify in this behalf. Stop. Although the discretion is provided in the said section, but it is held in different judicial pronouncements that grant of interest is the law and refusal is the exception. Stop. No, the question is, this is with regard to the adjudication in a claim case, not challenge against the order passing in non-awarding the interest. No, sir. So anyway, so this judgment is not applicable. Where is this observation that interest is to be awarded?
Lordship, paragraph number 15, Lordship.
No, this is the procedure followed by Honorable Supreme Court, High Court and Tribunal.
Lordship.
But regarding the proposition of law, anyway, I'm just not considering this. In the instant case, no special reasons is assigned by the learned trial judge as to why the interest is not awarded from the date of filing of the claim case till date of payment. Stop. Thus, the judgment and award passed by the learned trial judge should be modified. Stop. Hence, this appeal is disposed. The judgment and award passed by learned additional district judge, first court Jalpaiguri, on 20 February 2025 in MSC case number 26 of 2019 stands modified to the extent that the appellant is entitled to interest at the rate of 6% per annum from the date of filing of the claim case. Have you deposited the amount till the date of deposit made by the insurance company? Stop. Such payments shall be made within 5 weeks from the date of communication of this order. So they have to pay the interest only.
Yes, Lordship.
So from the date of deposit, from the date of filing till the date of deposit, they have to pay the 6% interest.
No, Lordship can be till the today, Lordship.
No. The moment the principal amount is deposited, interest stops running. So from the date of filing till the date of initial deposit, first deposit. Yes, before the tribunal. Now they have to pay this excess amount. That is, it should be paid within 5 weeks from the date of communication of the order. Yeah. Okay, sir, the payment with regard to the interest in terms of this order shall be made by the insurance company within 5 weeks from the date of communication of this order. Stop. The deposit in this matter shall be made before the registered circuit bench, Jalpaiguri, High Court, Calcutta, within the said period.
Grateful, Lordship.
First, I am for the appellant. I filed this affidavit in service.
Yes, what is the ground of challenge?
The ground of challenge is only for interest.
Yes.
Only one ground is.
So why have you not served him the copy?
Lordship, they have received the, just see the affidavit in service, they have received the notice on 24th December 2024. Exactly 1 year
No,
ago.
your learned
They did not
advocate-
come 8 or 9
Your
days.
learned advocate has not received the paper book,
Yeah, they have-
so
they
he
have-
is not in a position to submit.
They have not come, Lordship. The date, 8 or 9 days has been elapsed.
See, your learned-
The only one ground is there, only interest.
He cannot submit without getting the paper. Why didn't you ask? Why didn't you ask from him the paper books?
Just
Okay, today he's appearing today is for the first time, okay?
he is
So
for the
let it
first
be.
time, but company received the notice
No, but he
1 year
cannot,
ago.
he cannot submit without the
So
paper.
today I am filed the paper book before the London honorable court as well as the.
So let him take steps, let him come ready, let it be moved before the next. So can you get yourself ready within half an hour? Anyway,
We have
Yes,
submitted the.
yes. Learned advocates for the parties are present. Let the paper books file be kept with the record, let the matter be placed for the next circuit.
Lordship.
The 2:30 PM matter to take it. 2:30 PM matter.
Your Lordship,
Yes, what is the error?
the error is, Your Lordship, there's a deposit already made by the insurance company in this respect. There are two deposits. One is a statutory deposit, and one is in respect to the stay, Your Lordship. Lordship, can I stay the amount?
The statutory deposit and the, anyway, whatever it is, the entire awarded sum is deposited.
Yes. Along with interest, should
Appeal
be
is disposed.
appeal is disposed.
Appeal is remanded,
Have we disposed and remanded back?
remanded back.
Yes, Your Lordship.
That is why they are
You want to withdrawal of that amount?
withdrawal of that.
Yes, entire sum along with interest to be refunded to the insurance company.
Yes, record. দেখি রেকর্ডটা দেখি
And
আর লাস্ট ডেটের অর্ডারটা দেখি
And Your Lordship, if possible, Your Lordship can clarify one thing. Your Lordship has remanded back and stated that the learned trial court below should dispose of the petition on merit. Your Lordship, we haven't got an opportunity to file our written statement.
So
If Your
whatever
Lordship,
opportunity you want, you take from there, okay? I've remitted the matter back. So I've made the necessary observation. But have you paid the costs?
cost there's a time, Your Lordship, that we have a time
Cost
of
also.
around 4
Yes, learned adjudicate the claim case on merits.
minutes. So, if Your Lordship kindly clarify that we can file our written statement and file our evidence, because
Yes,
that has not been done.
Learned advocates for the parties are present. The matter is put up for necessary clarification and modification of the order dated 16/12/2025. By order dated 16/12/2025, the judgment and award dated 25/11/2024 passed by learned District Judge Alipurduar in MSC case number 29 of 2024 was set aside as the matter was remitted back to the learned trial court for deciding the same on merits. Stop. As the judgment and award was set aside and the awarded sum is also lying in deposit before this court, the appellant insurance company is permitted to withdraw the awarded sum along with statutory amount upon compliance of the necessary formalities.
Lordship, along with interest, also along
Whatever
with
it
along,
is, whatever you have
along with
deposited, you withdraw.
along with accrued
No,
interest.
that is
Otherwise,
not
they will
there.
not give.
Whatever is deposited, you withdraw. That is why I have clarified with upon compliance of all necessary formalities.
Your Lordship, but if Your Lordship doesn't direct for interest component, they will not give us the interest part. If Your Lordship does,
What is
along with
that? No, usually the procedure is whatever you deposited, that has to be withdrawn after deducting the expenses and all these things. Okay, that is the usual procedure.
accrued, along with accrued interest, there's this because it's in a fixed deposit account, Your Lordship. That's why.
Awarded sum along with the awarded sum and accrued interest.
Deeply obliged.
The prayer of the learned advocate for on the prayer by consent, it is by consent 16/12, the order dated 16/12/2025 is further modified that the insurance company, appellant insurance company will be permitted to file the written statement within 2 weeks before the learned tribunal, learned trial court.
After the necessary 2 weeks from the date of compliance. Your Lordship has already given a compliance of the
2 weeks
20.
after payment of the costs.
Yes, Your Lordship. Yes, Your Lordship. Deeply obliged.
Yes, call the next.
I've brought the other side.
It is for what, admission or hearing?
Yeah, you should.
Yes,
Lordship,
you have come against the order of the trial court.
Lordship,
What is the ground of challenge?
Lordship, I have prepared a page.
No, what is the ground of challenge?
That is one. Two pages.
What is the awarded sum?
However, sum is 8,91,000 Lordship.
No, what is the ground of
Leg,
challenge?
right leg is amputated. 11, permanently disablement is 81%. income took 60%. That would be 100%. And I have paid, Lordship, I cited 3 judgments.
But in your written notes?
Yes, with that. I did written notes in that. Just check it. Income and certain heads as missed by the learned trial judge.
This is the judgment of our court.
Lordship.
The other is of the Supreme Court.
One, 2 judgments of this court, and one is Supreme Court.
Yes, what you say? What was the notional income taken?
Lordship, only 6,000. Grocery shop owner and labor is same. And this accident took place in the year 2019. And that notional income of labor took in the year 2016. Lordship, whatever
Is it a
you.
permanent disability?
Yes, 81%.
Okay, that is the formula.
Right.
And the other is medical treatment and pain and suffering.
Right leg is amputated.
And the annual income comes to 12,672
That is too low.
on the 80% of 72,000.
60, they have taken 60%.
No, but as per the permanent disability, how much it is?
81%
From by the medical board.
by the medical board.
But that was not proved
That document was exhibited.
Executed, Lordship. Page number 28,
28.
paper board.
It requires review after 5 years. Okay, review after 5 years. So the incident took place 2019.
90.
5 years comes to 2024. And judgment delivered
2020, Lordship.
20?
4th January 20.
Okay, record an order. Learned advocates for the parties are present, heard learned advocates. Hearing is concluded. CM.
was not mentioned in this parent. That not clearly.
That may be, if
That
Lordship,
means whatever is the income, notional income, and notional, you are only contending on notional income.
personal income, Lordship, that should be high and a trial just taken 60% of the total income, that should be 100%. And future prospect is allowable in these cases.
No, have you, is there any
I
ground?
have given Lordship citation.
No, grounds, in your grounds have you taken?
Lordship.
In your grounds of appeal, have you taken that?
Lordship, in roundabout, right, but I may.
Anyway, if you have not taken that grounds, if you are not active.
Lordship, I may, in the last line of the appeal, we may place other grounds before your Lordship. If Lordship permits, it would be asked. If not, that would be not asked.
So simply your oral submission.
Lordship, I have given the written
Yes.
notes of argument, whatever it is. Lordship,
রেকর্ডটা ইয়ে করে সিএবি করে ওখানে যাবে আর কি।
grateful Lordship.
For the petition. This is an application for,
It is for the first time.
it's for the first time. For expeditious trial of a matrimonial suit, my lord. Now, my lord, if your lordship can you take,
When did you find the suit?
my lord, suit was filed on 16/11/2024.
So what expeditious trial do you want?
My lord,
You have filed a case in 2024. When is the next date fixed?
now, my lord, next date, the respondent appeared on 26th June
the matter-
2025.
No, matter was sent to mediation.
Mediation report has been not been received. Next date is 17th January 2026.
So mediation has not, so
Mediation has been failed. So my humble submission before your lordship, the matter may be admitted and let us inform the other side. I think no one will be prejudiced if the matter will be expedited.
So let the matter be placed before the next circuit, you
As
serve
your
notice.
lordship,
Serve notice.
okay.
Learned advocates for the petitioner is present. Our learned advocate for the petitioner. Let notice be issued upon the opposite party.
My lord,
Let the matter appear before the next available circuit.
grateful.
Then I'm praying for not today.
Okay, not today.
Item number. The playing seeking transfer of a matrimonial case. Matter from Alipurduar to Jalpaiguri.
So serve notice, yes, record an order. Yes, keep the PTA record টা দেখি একটু। Learned advocate for the petitioner is present. This is an application under section 24 of the Code of Civil Procedure filed by the petitioner seeking transfer of the matrimonial suit pending before the learned additional district judge, second first rank court Alipurduar, to learned district judge Jalpaiguri. So let notice be served upon the opposite party, an affidavit of service be filed. Let the matter appear 3 weeks, or let the matter appear about 1 week after vacation before the next available circuit. As the matter is sub judice before this court, the petitioner may seek adjournment before the learned trial court, which may be considered.
Item 12, I'm praying for not today.
Not today. Are to matter नहीं. Yes, any other extreme urgent matter for extension of interim order or stay?
Your lordship, one stay matter is there. Item 34.
Item 34.
Yes, your lordship.
What is the defect?
Your lordship, I'm not aware. I have filed the CAN application. I have been told by the department I haven't filed the CAN. That's why there is a defect. I filed the CAN application. And
No,
the appeal is within
that is
time.
section 5. Can means
No,
what?
no section 5. No section 5. Appeal is within time, your lordship.
देखिए record take.
My lord, for item number 32 and 33, I mean, both the matters are arising out of the self-same judgment, and here both the appeals have been filed out of time. And my lord, accordingly, the
34,
32 and 34, my lord.
33 and 34.
32 and 33.
No, I have now taken up 34. Okay.
Oh,
Just a minute. 34 এ কি defect আছে? Yes, you have not deposited the statutory amount. That is
I
not-
have deposited. I have deposited. Your lordship, kindly record.
Okay. I am placing it before the next circuit.
Your Lordship, stay is pending, that's why. Your Lordship.
You see, you instruct somebody on the next day to
Yeah.
file that statutory, file that challan.
I can do it right now. I can do it in the course of the day. I will do it, Your Lordship. I have my clerk there. He will deposit within the course of the day. I will satisfy Your Lordship with that.
But you
Your
have
Lordship
not
can
filed any application for
recall my
stay
submission.
also. You have not filed any
Stay,
application for stay. Where is
the
that
stay,
application?
the stay application
The
is also
application is there.
there, Your Lordship. Yes, Your Lordship. Can has been filed, Your Lordship.
Can has been filed. Yes, record an order.
Yes, Your
Learned
Lordship.
advocate for the appellate insurance company is present. It is submitted by the learned advocate for the appellate insurance company that statutory amount is already deposited. Stop.
Yeah.
Thus,
Your Lordship, white challan number 69, dated 8th December 2025.
okay. Thus, considering the submission of the learned advocate for the appellant, this court is of the view that some limited protection should be given to the appellate insurance company. Thus, the judgment and award dated 22nd August 2025 passed by learned additional district judge, first track second court Jalpaiguri in MSC case number 600 of 2022 shall remain stayed for a period of 5 weeks from date. Stop. The appellant insurance company shall deposit the entire awarded sum along with interest, excluding the statutory amount, within the period of 5 weeks. Stop. In the event such deposit is made within the period of 5 weeks, the ad interim order of stay shall continue till disposal of this application. The challan or showing deposit of rupees 25,000 shall be filed by 2/1/2025. 2/1/2026. Yes, liberty to mention. Yes,
My lord, I'm here for item number 32.
32, yes.
My lord, I am
Oh.
here for the appellant for item number 32. My lord, 32.
Can one is for what? Can on what?
The delay application, my lord,
Huh?
there are,
Don't-
yes, yes, my lord. 34.
33.
I am the appellation committee, company has also filed the appeal.
So both are the section 5 application.
Yes, my lord. My lord, there are 553 days of delay for us in.
Anyway, let me see.
Thirty-two and 33. My lord, both the appeals are arising out of this same judgment.
आगे 32 টা দিন হ্যাঁ 32 it can take. Yes, record an order. Learned advocates for the item 32. Learned advocate for the part can one. Learned advocate for the parties are present. The application for condonation of delay is taken up for consideration. Heard learned advocates peruse the petition file. Upon perusing the petition and upon hearing the learned advocates, this court is of the view that the grounds furnished with regard to delay is sufficient. Thus, delay is condoned and the appeal is admitted. Can 1 of 2025, stands disposed. Stop. As the learned advocate has appeared for behalf of respondent number one insurance company, service upon respondent number one is dispensed with. The appellant shall take steps to cause service of notice upon the other respondents.
My lord, let there be the direction to call for the trial court record and also,
The trial court records
to
be called
prepare
for at the special messenger post of the appellant.
My lord, let there be the direction to prepare the informal paper books.
The informal paper book be filed upon arrival of the trial court records.
Grateful, my lord.
Liberty to mention. Yes, next case. Yes, next case, you are for the respondent. You are the respondent. Yes, here is also a condonation of delay. হ্যাঁ? না কিন্তু নাম্বারটা না নাম্বারটা ইয়ে দেখাতে হবে reflect করতে হবে। Yes. Yeah, learned advocate. Can one is
delay and can do stay.
yes. Learned advocates for the yes, you are for the respondent. Learned advocates for the parties are present. The application can one of 2025, which is for condonation of delay, is taken up for consideration. Heard learned advocates peruse the petition file. Upon hearing the learned advocates and upon perusing the petition, this court finds that the delay, the grounds for delay furnished is sufficient. Thus, delay in filing this appeal is condoned and the appeal is admitted. Stop. Can one of 2025 stands disposed? As respondent number one, claimant has already appeared. Service of notice upon respondent number one is dispensed with. Let service be effected upon the other respondents. Let the trial court, yes, in the other matter, I have directed trial court record, so it is not necessary. Okay, liberty to mention. Acha, even can one. Can two. The application for stay is taken up for consideration. Are learned advocate for the parties. As the appellant insurance company has deposited the statutory amount of ₹25,000, there shall be an ad interim order of stay of the judgment and award passed by learned additional district judge, First Court Jalpaiguri, in MAC case number 166 of 2016 for a period of 5 weeks from date. Stop. The appellant insurance company shall deposit the entire awarded sum along with interest, excluding the statutory amount, within the period of 5 weeks. Stop. In the event the entire awarded sum is deposited within the period of 5 weeks, the interim order of stay shall continue till disposal of this application. Liberty to mention. $67 is what for stay.
In 66, I am for the appellant. There is no delay. Appeal has completely appealed.
So 66, there is no delay. Oh, already admitted, only 67. Just can one. Yes, record an order. Learned advocate for the appellant insurance company is present. Learned advocate for the appellant and learned advocate for the respondent number 1 are present. Are learned advocates. This is an application under Section 5 of the Limitation Act filed by the appellant, praying for condonation of delay of 32 days. Stop. Upon perusing the petition and upon hearing the learned advocates, this court is of the view that the grounds furnished for condonation of the delay is sufficient. Thus, delay is condoned and the appeal is admitted. As respondent number 1 has already appeared, service of notice upon respondent number 1 is dispensed with. Let service of notice be effected upon the other respondents. The trial court records be called for at the special messenger cost to be paid by the respondent number 1. The informal paper books be prepared upon arrival of the trial court records. Liberty to mention. There is another application. Oh, then how can they? But you have only deposited statutory amount. Where is that challan? So actually, without application for stay, how stay can be granted? Anyway, I'm staying it for a limited period, subject to filing formal application. Learned advocates for the, it is submitted by the, actually liberty to mention the kid for a last event. It is submitted by the learned advocate that statutory amount of rupees 25,000 is already deposited, and the copy of which is filed by the learned advocate. Stop. Is filed by the learned advocate. However, learned advocate submits that a formal application for stay could not be prepared and prays for liberty to submit a formal application for stay on the reopening date of the court. Stop. As the appellant insurance company has deposited the statutory amount, there shall be an ad interim order of stay of the judgment and award dated 28/1/2025, passed by learned additional district judge, first court Jalpaiguri, in MSC case number 58 of 2018 for a period of 5 weeks from date. The appellant insurance company shall deposit the entire awarded sum within the period of 5 weeks, along with interest as directed by the learned trial court. However, such deposit shall exclude the statutory amount. In the event the entire awarded sum is deposited within 5 weeks, the ad interim order of stay shall continue till disposal of no. There is no application. In the event the entire awarded sum is deposited within the period of 5 weeks, and a formal application for stay is filed within on the reopening date of the within 1 week after vacation. 1 week after vacation, the ad interim order of stay shall continue till disposal of the appeal. So you have to file a formal application on the reopening of the court within 1 week after vacation, and you have to deposit the entire awarded sum. Because unless you file the formal application, that will not continue that interim order.
Item number 66.
তার আগেরটা বলুন কি বলে? Till disposal of this appeal.
No, in item number 66,
Yes.
along with 67, may I permitted to submit a paper book? The learned court as well as the learned advocate for the, as there is a direction to prepare the paper book.
Within the next circuit, the paper book. Acha, লিখে দিন তো, learned advocates are present. The paper books file be kept with the record. Let the matter be placed within the next circuit. এই এটা রেখে দিন রেকর্ডিং। Yes, yes. So what can be done? You see, but there is no time today. So get it hard before the next circuit. Yes,
Can. I'm hearing.
oh, it was a review matter. Recall matter. I have some doubt whether this bench can have, whether it should be, require some assignment or not. 58? What?
No, actually 58 for, I'm for the appellant, 59 for the, he's for the insurance company.
Okay, this will be the last matter, 59. What is the urgency?
My lord, matter has been appeared in the circuits in circuit as well. But it's not, they are not appearing, but we are not. But
It is a motor accident claim case.
oh my God.
Anyway, you see, now I am not in a position to take up the matter, so you mentioned it before the next circuit. Yes, 59 will be the last matter. What is the defect? You remove the defect in the next circuit?
Actually, after the judgment, it was passed, the appellate died.
So take steps.
You can file an EQOP application, file EQOP. Only that was able to.
No, no, the other side is there.
No, my lord. It's second appeal.
Can one is for what?
Can what is one was stay here.
Stay. So how can it be, how can there be a stay?
Combination or delay also. You have to file, but first the defect needs to be cured.
Just a minute. So 58 is an admitted, already admitted.
I have submitted that paper.
So can one is what? Stay within the period of limitation. 59. 53? No, 53 or 59 can, another thing.
Yes.
53, এটা কি 53 দিলে? ও আচ্ছা আচ্ছা। Okay, okay. So is that how you have filed the statutory amount?
I have given the.
Yes, record an order. Done it. Can one is your application for stay? Learned advocate for the appellant and learned advocate for the respondent number 1 are present. As the appellant insurance company has deposited the statutory amount of rupees 25,000, there shall be an ad interim order of stay of the judgment and award dated 2nd day of April 2025, passed by learned additional district judge, 3rd court, Jalpaiguri, in MSC case number 437 of 2019 for a period of 5 weeks. Stop. The appellant insurance company shall deposit the entire awarded sum along with interest as directed by the learned trial court within 5 weeks. Stop. In the event such deposit is made within 5 weeks, excluding the statutory amount, the ad interim order of stay shall continue till disposal of this application. Stop. Liberty to mention. As the paper books have already been, next item 58. It's a composite paper book.
Yes. Yes.
So let a composite order be recorded.
Yes.
58, 59 is of এক order, ঠিক আছে? As the paper book is filed by the learned advocate for the respondent number 1, let the same be kept with the record. liberty to mention.
Item,
Item 54 টা রেখে দিন তো।
scan one is for condonation of delay, my lord.
51, 54 is what? This is condonation of delay.
Yes, my lord, but I had mentioned for my lord's.
No,
curing
no,
the
what is
defect.
the defect? Have you
The
seen? what
defect is
the
that,
defect?
my lords, the appellant had died after the judgment and he was passed. And
Just a minute.
his legal heirs has been made a party minus directly without filing any leave to appeal.
Just a minute.
And my lords, it's there in the stamp reporter's report. My lords, it's written at the very last part.
There is no delay. Yes. Now what is there is, is found that plaintiff number 3 of the title suit died after passing of the judgment and decree.
Yes, ma'am. So he has not.
Legal heirs of the plaintiff number 3 has been made party in the title appeal.
Yes, ma'am. Inadvertently, my lord, without filing an application for leave to appeal, they have been made party directly. So, my lords, probably
Yes,
this
recorded order.
matter needs to be, my lord.
Learned advocate for the appellant is present. Learned advocate for the appellant prays for leave to remove the defect. Thus, steps be taken by the, to remove the defect, the step be taken by the learned advocate to remove the defect and thereafter mention the matter.
And my lords, the application for leave to appeal will probably be heard by the division bench, my lords.
No, first of all, you remove the defect and mention the matter.
My lords,
So
that
the-
is the defect that we have to file an application
Yes, sir.
for leave to
Whate-
appeal.
Whatever you do, I have granted you the leave and mention before the appropriate
My
bench.
lords. I'm grateful.
If it is a section 5, then whatever it is, it has to be by the single bench. Otherwise, all division bench. Okay, okay, thank you. Thank you. Enjoy your holidays. Next, we will meet in the, probably in the next building.